Dear friends, today in this video we are going to see how to draft a legal notice. Before drafting a legal notice, there are some important steps to be followed by an advocate. I hope that this video will benefit for those lawyers who have started their individual litigation practice. Step number one is a detailed discussion with the client. So when a client comes to our office with his case, the first and foremost, you should allow the client to speak up about his case. You should not interfere or interrupt when the client reveals the facts of his case. And more importantly, an advocate, you should take a A4 sheet paper, and when the client starts narrating his case, you should take notes from the facts which he reveals. And once the client completes his narration of facts, after that, if there is some clarification, you can discuss with the client. If you interfere the client when he is narrating the facts, he will lose his emotional temper and flow, and thereby some important, most crucial facts he may forgot to convey to you. So it is highly recommended not to interfere or disturb the client's narration. After taking the notes, then the advocate has to ask the client what are the supporting documents, evidence, and relevant materials which the client relies upon to substantiate his case. This is very important. It is not the facts alone the lawyer is going to file as a litigation before the court. The facts coupled with documentary evidence will also be filed as a litigation before the courts to adjudicate. So it is very pertinent to ask the client what are those documents he relies upon. If the client gives some supporting documents and records, after that a lawyer should analyze the facts, and it is more crucial that in order to succeed in a given litigation, the advocate has to thorough and marshal the facts which have been narrated by the client. After going through the facts, after doing the analysis, now an advocate should look what are the applicable law which is involved in the given facts and circumstances of the case. So what can be done is, now it is advisable to let off the client and to say to him to come for second sitting so that the proposed case can be finalized. And generally, it will take 2 or 3 days to do some basic research of the client's case. Now, what the lawyer should do is, he should try to construct a blueprint. What is the litigation is all about? Number one. Number two is, drafting of the legal notice is nothing but a road map which leads to a litigation, and what are the factors that has to be taken into consideration in order to get a relief to the client from the courts of law. So a lawyer should take it very seriously, because legal notice is the fulcrum which initiates the process of the litigation. So a lawyer should be vigilant and should be cautious and do a legal research in order to make the case success. So after 2 or 3 days, when the lawyer finishes his homework on the given case, then there is some ray of hope which leads to the litigation to be get succeeded. Then you call the client for the second sitting. By this time, an advocate should be in a position that at least he should have a draft scheme how he is going to conduct the litigation before the court, and what would be the pros and cons of the cases, and a 360-degree approach should be given in all aspects of the facts and circumstances of the case. Once the client comes in the second sitting, then you can start drafting the legal notice with the presence of the client. Always it is highly recommended to draft a legal notice in the presence of the client, because sometimes when the facts are drafted, some facts may not be revealed at the earlier discussion, that will come into light, and even the client will be in a position to recall some missed out facts which are very relevant to the given case. Therefore, what are the shortcomings and the gaps which has been left out in the previous discussion can be covered in total in the second sitting. Now, drafting the legal notice, the first and foremost is to whom the notice is addressed. Now, in civil cases, the client is called as plaintiff, and the legal notice is opponent is called as defendant. So the defendant name, his address should be clearly mentioned in the legal notice. If he is an individual, his name, his father's name, his age, and which street, which area, locality, state, district, pin code, everything should be mentioned clearly. And if it is a corporate entity, LLP, a private limited company, a proprietorship concern, or a partnership firm, then the directors of the company, managing director, the manager who is authorized to sue on behalf of the company, and the in partnership firm, the partners, everything has to be clearly mentioned in the notice with address. The purpose of this, that the legal notice should be promptly delivered to the opponent person, so that there should not be any disappointment of non-delivery of the legal notice. After this, the paragraphs should be numbered, and the finalized facts, those relevant facts which are to file a case, should be drafted in a chronological manner. A year wise it should be drafted. Earlier year, if the client is providing the date, month, it is very good and more effective. At least the client should recollect the relevant year of the events which happened between him and the opponent, so that the paragraph should be numbered and the sequence of the events which culminated into a legal action against the opponent, the defendant in civil case, should be arranged chronologically, cogently and coherently. The next important thing is, when using the English language in the legal notice, an advocate should use simple words in clear terms. Avoid using legal jargons, those sentences which involves legal implications. Usually what happens, a legal notice is always addressed to an individual or any other entity who is not expert in a law field. Of course, they may have some basic understanding of the law, but they could not able to appreciate the legal nuances which you have incorporated in the legal notice. Therefore, keep the legal notice in a very simple terms, in brief and very precise, what your client demands from the opponent. That should be in very clear terms. After drafting all the facts, the last concluding part of the legal notice is the prayer. That is the demand, the relief which you want to give for the client. That should be very clear, and there should not be any ambiguity while demanding what your client wants from the opponent, the opposite party. So after completing the legal notice, you should give one copy to your client to go through it, to check whether all the relevant facts which are material to establish the cause of action in favor of your client, and who is legally entitled to sue his opponent before the court of law. After everything is over, you have to go through the checklist of the legal notice. What are the checklists? Number one, whether the opponent's name, his designation, his present occupation, his present residing address, or in case of company, the registered office, everything has been mentioned accurately. Number two, whether you have categorically numbered the paragraph in the legal notice, that you have to check. And last but not least, the signature of the client is very important. So each page, at the bottom of the legal notice, the client should sign. This is in abundant caution. Tomorrow the client should not take back his statements what he narrated to the advocate. Therefore, he should approve what is stated in the legal notice is what actually has been instructed to an advocate to draft the legal notice. Then date, month, year should be mentioned in the notice, and whether the notice is sent by a courier or registered post with acknowledgement card, that has to be mentioned in the legal notice. And after finalizing the legal notice, take minimum 4 copies, or it will sometimes 5 copies also. All the original legal notices, one is should be given to the client, one should be retained in advocate office as a case record, and another one is should be kept for filing at the time of the litigation, and other extra copies for any situations occurs in future, those copies can be used. So after finishing all the formalities and before dispatching the legal notice, if it is going through a registered post, what an advocate has to do is he has to mention on the ID card in small figures on the top of the ID card that this is the legal notice dated, for example, 2nd November 2024. In small figures on the top of the ID card, if it is mentioned, more than enough. What is the purpose behind it? See, in one single case, there will be several correspondence between the parties. A legal notice will be sent, and the opposite party, once he receives the legal notice, he will send a reply legal notice from his lawyer, and after going through the reply notice, then advocate, there may be a situation arise, a rejoinder notice should be given to that opposite party. So several correspondence will be done between the client and the opposite party. So one will not know in different AD cards which an advocate receives, which AD card is corresponding to the particular legal notice sent. So therefore, if a legal notice dated is mentioned on the AD card, that can be clubbed with the corresponding legal notice so that confusions can be avoided while filing the litigation. So these are all the most important aspects and factors that has to be taken into consideration before drafting a legal notice.